Welcome to the Spiggle Law Firm podcast, where we help people who've been fired or afraid that they might be. We also talk about cutting edge employment law issues in the news. My name is Tom Spiggle. I'm the founder of the Spiggle Law Firm, and today I'm thrilled to be joined by a repeat guest on our show, a senior attorney in our office, Louise Ryder. This is going to be a continuation of our series on federal sector litigation. I urge you to check out some of our previous episodes where Louise has shared her extensive knowledge about the process, and we've started from the beginning. What happens when you go to that EEO officer through the ROI process to selecting the next stage in the litigation, whether it be a final agency decision or whether you go to the EEOC. And if that all is Greek to you, check out our previous episodes because Louise really lays that out in detail. In this episode, Louise and I are going to be talking about the process, what happens once you get to that EEOC judge, and we're going to go through the summary judgment stage. And then in second episode and subsequent episodes, we'll be talking about what happens summary judgment onward. But before we get there, a little bit of legalese. This podcast is not intended to create an attorney-client relationship with the Spiggle Law Firm, nor is it intended to provide specific legal advice for your situation. If you want either of those, then you got it. You should go hire an attorney. Well, welcome back, Louise. Thanks for joining me again.
Thank you for having me.
Okay, so we last left off, the client has come to the fork in the road. They can either choose a final agency decision or they can go the EEOC route. You explain the pros and cons of both of those, but now this person has chosen that fork in the road. They're going to the EEOC. What's the first thing that happens?
Generally, you'll get assigned to an administrative judge, and there can be a period where things are pending a little bit, but the EEOC in the last year or so has really sped up how fast you get to an EEOC judge. And once you get assigned to the judge, they will issue an order. They will issue an order scheduling an initial conference, and then that order will outline issues that the judge plans to raise during that initial conference and what topics the judge will be talking about, considering. And usually those subjects would be what claims are at issue, which would include if there's any amendments that need to be done or clarifying claims, which comes up a lot. So essentially, because the agency is articulating, prior to this point, the agency has been responsible for articulating the actual claims at issue. They'll review what you submit if you're pro se, or even as an attorney, and they'll rephrase it in their own way and create claims out of it. So once you get to the administrative judge, during the initial conference, there will be a discussion of whether the claims as laid out by the agency in the report of investigation, in their notice of acceptance, if those are the claims that should be litigated, or if there are either missing claims because the agency dismissed certain claims. You should be prepared to discuss that and explain why the agency erred in dismissing claims. Or if you have a new claim that came up, definitely make sure that you've raised it within 45 days before you do that. And for instance, sometimes at the end of the investigation period, if you say, hey, I have a new amendment, occasionally the agency, instead of including that amendment, will say, you know what, we're not going to agree to amend your claim, file a new claim. And one thing you can do is, if you're filing a hearing request, is instead of filing a new EEO claim, you can file a motion to amend your claims before the administrative judge, as long as, again, you raise the issue in writing to the agency or to the administrative judge within 45 days. Consolidation of claims. So if you have two different EEO claims that have had the report of investigation issued, then a lot of the time those claims will be consolidated once you go to the administrative judge. The judge would prefer to consolidate them. Now, there are different circumstances because timelines can vary. If you have a second claim that is still in the investigation stage, but is almost at the point where you're going to get the report of investigation, you would still want to notify the judge of any other claims you have. And sometimes the judge will say, you know what, we're going to wait for that report of investigation to be issued and we're going to consolidate both cases. Sometimes the judge will say, no, we're going to process them separately, but it's a discussion to be had. The last category would be rephrasing claims that may have been accepted, but if they mischaracterize what your allegations in any way. And so that's where we get into clarifying the claims that are already a part of what's going on.
And I think that's an important point you raised about the 45 days, which highlights, it's really important to tell your attorney if there have been changes, if there have been new things that needed to be added, because you do have, it's one thing about the federal sector process is it tends to have very short deadlines. So you may want to make sure that you're on top of that.
Absolutely.
All right. So what happens next?
All right. So initial conference, there will be a few other subjects that are addressed. And so again, claims would be one usually, and then discovery would be the second topic that's discussed. And one thing that the judge will want to go into is what discovery still needs to be done, and what is already covered by the report of investigation. And so you want to be prepared in that call to explain how the report of investigation is missing key documentation or information that you need to prove your claims, because the judges have an obligation to make sure that there is a fully developed record. But you aren't entitled to unlimited discovery like you would be in, say, federal court. And so this really depends on the judges. A lot of judges will have a presumption that, most cases I give people 25 interrogatories, 25 document requests, 25 requests for admission. But some judges are a lot more particular. And this is also, it does vary a lot how the judges handle the initial conferences. So, I've even had one judge that he wanted me to identify exactly every interrogatory and document request during that initial conference. And so, for instance, he wanted me to ask the agency every single question that I wanted to ask them that I needed information for, and identify exactly what documents I was requesting. That is rare because most of the time those are written. So you write out the three categories. I don't know if we addressed these before. There's interrogatories, which are basically questions. So you're asking the other side a question that they have to respond to and provide the information responsive to that question. 2 requests for documents, where you're asking them for a certain type of documents that they have to provide. And requests for admissions, where you say, admit that on this date, so-and-so issued my clients a letter of reprimand, or whatever it is that you want them to admit, and they have to say admit or deny. So most of the time those are developed it takes a few hours to prepare those requests. And so it's not very common where you'll have to identify each of them during the initial conference, but it's happened. So just make sure you're very familiar with the report of investigation, what is in it, and what you need for your case and why.
Just real quick, an important difference. We talked previously about what it's like if you go to federal district court, which is slightly different than going before an EEOC judge, is this initial conference you're talking about. The judge is much more involved than you will see in federal district court, either in a federal sector case or private sector. So if you know somebody who was at a private sector case, so they don't work for the federal government and they've gone through this process, it's very different. Usually the judge have a pretty set, what we call scheduling order, where they'll say, like you said, Louise, like you get, 30 interrogatories, you get an X number of requests for, document production, you get X number of requests for admission, go parties, you guys, figure this out. And so you don't have that deep dive kind of more granular involvement by a judge, which can be helpful helpful to have the involvement by the judge, because the judge can help kind of streamline the issues, because when you're in federal district court, the parties are fighting that out on their own and then going to the judge if and when they need to. And that can just take a lot of time and therefore a lot of expense. So I think there are certainly some benefits from having a judge who's experienced in these matters jump in and maybe sometimes too much, but try to, at the outset, set the parameters for the case.
And it also, discovery does tend to be very slightly less in the EEOC, in that, the length of time is usually less. So usually the most you're going to get for a discovery period at the EEOC is 90 days, whereas in a lot of federal courts, it might be 120. Usually the most interrogatories, requests for documents, requests for admissions you'll get is 25 of each at the EEOC, whereas it might be usually 30 of each at the federal court. And same with depositions. And the administrative judge will also, as a part of the discussion about discovery, want to know who you want to depose. And a lot of the times they will limit it to 3-4 people. It really depends on the circumstances. Most judges are very fair, and if you explain, here, these are the people we need, and this is why, and it's compelling, they'll let you depose them. They also, if you find it later on because of some new information that you need additional depositions, need to take more depositions, then you can always file a motion to request more depositions. But it's always better to be prepared during this conference by knowing exactly what you need in discovery.
Yeah, and just a quick aside about requests for admissions. This happens in any kind of litigation. I think people sometimes get confused by it because a lot of times we are asking for very basic information, usually things that the parties don't dispute. And the reason for it is like, there are all these things in your head that everybody knows, right, about whatever the situation is. I'm going to use a basic example, but like, everybody in my family knows, let's hope when my birthday is, it's October 2nd, but that's not in a judicial record. And so to get it in the record, sometimes you have to have those requests for admissions. And they can be really helpful because they, first of all, narrow what the parties are disputing, because the request for admission, everybody agrees this is what the fact is. But then it also is something that you can cite in the record, because if it's not in the record, at least in the legal system, it doesn't exist.
Absolutely.
All right. So what happens next? We've got kind of our initially scheduling conference done. We've got what the parameters of discovery are. We've got the issues, right, that have been resolved by this point. Is that right?
Yes. And so also, and I didn't think to mention this earlier, so the initial conference, so usually discuss the claims, discovery, and of course scheduling, which we usually request 90 days. And then, and also the scheduling of motions, etc. So I always prefer, because sometimes discovery requires extensions due to the unavailability of opponents, and this is a big part, trying to get the information you need where the agency doesn't want to provide it, and get into a battle about that. And so I always prefer that instead of setting a specific time for dispositive motions, which is a motion for summary judgment, the next step, that you keep the standard 15 days after the close of discovery for the motion, 15 days after that for the opposition, and then I think it's 5 or 10 days for the reply. I can't recall. But because those dates change, and I always prefer to do fewer motions to change the dates in the order, because judges don't love those motions.
Yeah, no, they don't.
And then the last subject, and they may not be discussed in this order, but would be settlement discussions. The judge will often want to know an update as to whether we have provided a settlement offer, whether the agency has responded. And generally, most of the orders will state that you need to provide a settlement offer perhaps 2 weeks before the initial conference, or however long, to the agency, to enable the parties to get into a dialogue before the initial conference, so the judge can have some assessment of whether maybe this case can be settled. Maybe the judge will want to refer it to mediation. They'll want to know what the different offers are on the table, what the current stature is, and whether each of the parties are interested in mediation. So it's good to have that. Make sure that you send out your settlement demand by the time listed in the order. And these orders, another thing that makes them very different from federal court is they are lengthy and detailed, and every judge's order is different. You have to read every word in there. A lot of the time there will be, I've seen deadlines listed in footnotes. So just make sure you carefully peruse those initial orders.
Yeah, I think that's a huge point about the settlement, because really up until this point, there hasn't been much of an opportunity and certainly not much of incentive on the federal government side to even engage in settlement. Early in the beginning of the process, there's the possibility for settlement, as we talked about in some of our earlier episodes, usually non-monetary, but there's an opportunity. You're actually each side's talking to some degree, you can settle it. But during the investigative phase, you're not even talking to an attorney on the other side. Like there's no real impetus to settle the case. And that certainly would be true, as we talked about in our last episode, if you're going for a final agency decision. I mean, I imagine the chances of settlement in that process are very low because, again, they're at the mostly they're just going to, rubber stamp, the report of investigation, which is a decision against you. So this is really the first option that you have to get your case settled. And it's this is a judgment call, because this process, and we'll talk about this more in a minute, can be very expensive because, you're engaged in full tilt litigation. It's not as expensive as being in federal district court for the reasons that we discussed, but it's not cheap. That said, you can play a little bit of a game of chicken here, because this is your first opportunity to try to get the case settled. And the judges want cases to settle, right? They want to clear their docket. It's harder for the agency to kind of play a game of rope-a-dope and really kind of bleed you. It doesn't stop them from doing that, but at least you've got a judge saying, hey, agency, what, have you come to the table with anything? So if you are in a situation where, you're watching your funds and you're like, which way do I go? I mean, you should talk to your attorney about this, but this is one way to like, okay, I want to settle this case. I want to at least get that shot. And you're not going to get that until you get to this segment of the litigation. So it's something to think about. Like, yes, the process is expensive, but if you settle it, it ends it, right? Like there's no, the expense doesn't continue as if you went all the way to trial.
So yes, after this conference, then there will be an order issued. The judge will send out an order following the conference outlining all the decisions that he or she made. And then you usually start discovery. Sometimes the judge will provide dates for motions to amend, motions to clarify the claims, things like that. Or sometimes the judge will refer the matter to mediation first. But assuming none of those happen, then you go straight to discovery.
And then it's just you're going through the process, right? You are asking the interrogatories, you are requesting the documents. Depositions take a little bit of time. I think most people know what depositions are, but for those of you that don't, like this is where, as the employee, you're going to get your deposition taken. You get to take through your attorney depositions of key players on the other side. You sit down with a court reporter. All the parties are sworn in, or the person who's taking the testimony, giving the testimony, is sworn in. And it's very similar to giving testimony in court. So you can use these answers in court proceedings. They take a lot of preparation. They take a lot of work, depending on, what the subject of the deposition is and who's being deposed. It can take all day. So these are really where sometimes the rubber meets the road. And usually the depositions are taken after the other discovery is finished. So you've got the documents, you've got the interrogatories, and you can come and you can ask people about those sorts of things. So just so folks know, what we're talking about, we talk about depositions.
I do think that it's always good to note who you plan to depose earlier on, because I have seen, if you wait until written discovery is concluded, at the EEOC, most often you end up in a situation where there's rolling document production, because the agency, it takes much more time for them to get documentation, and judges are usually very flexible with that. And so you don't want to wait until the end and all of a sudden you're trying to schedule depositions, but nobody's available that next week. And the judge says, you know what, I'm not going to extend discovery anymore. And then you might not be able to take the deposition. So what I always do is try to make it clear from the beginning, look, we're going to schedule these depositions, but we need to receive the agency's complete responses first, and just make sure you keep the judge aware of what's happening in terms of if you have to push back depositions, and if it's going to come up on the close of discovery, you're going to want to file that motion to motion to extend discovery as necessary. In addition, most of the time when you're dealing with interrogatories and document requests to the agency, you're going to have to fight for a lot of the documents you really need. And what that means is, again, review the judge's orders because they all have different requirements. But what we often refer to that process as is motions to compel or discovery motions. And so you will likely have to reach out to opposing counsel, say, hey, here are the deficiencies in your responses. I need you to give me this, and list it all out. And probably have a phone call with them to discuss whether they're willing to supplement or to address any of those concerns. And then if they decline to do so, then you'll have to usually email the administrative judge, advise the administrative judge of exactly what the deficiencies are, provide a copy of the discovery request, discovery responses, and usually provide 3 dates that you and opposing counsel are available for a verbal conference with the judge. And that's when the judge will go through each of them and say, agency, provide A, C, and D, but you don't have to provide B. And then you'll have to wait for the agency to get you those documents as well.
Got it. And again, I know this varies, can vary widely, but how much does it cost? How much time are we talking from the time of that initial conference until the close of discovery?
The initial conference, because of all the preparation involved, it could be $5,000 if you include the conference, the settlement communications, the review of the ROI. Again, it can vary, but that perhaps on average, that would be my guess. Discovery, my guess would be $15,000 to $20,000, assuming you probably want to take a few depositions. So it's one of the more extensive parts of this process where it's going to take a lot of time, a lot of effort to get out those discovery requests, discovery responses, and mostly, and this is where a lot of that money goes, is fighting to get the documents and information you need. So the motions to compel, the discussions back and forth, the reviewing the agency's discovery responses, and then, of course, the depositions. Those are probably one of the most expensive parts.
Yeah. Good. Well, it's been very helpful. Anything else you want to add on the discovery process or anything we left out?
Not at this time.
Okay. Great. Well, as always, thanks, Louise. I'm going to let you jump off. I'll say goodbye to our audience, and then we'll continue next time with what happens when we get to summary judgment.
Thank you very much.
Okay. Bye, Louise.
The day.
Well, thank you for joining us on this episode of the Spiggle Law Firm podcast, where we talk to Louise Ryder in our continuing series on federal sector litigation. Today, we talked about what happens when you get to the EEOC stage and the initial conference through discovery. In our next episode, we'll be talking about the summary judgment process. If you found this helpful and you'd like similar information, you can go to our site, thecareerrocket.io. Gives your email address, and weekly you will get cutting edge employment law news and tips and tricks on how to keep your career on an upward trajectory. As always, you can get a lot of great information directly from our website, spigglelawfirm.com. Finally, if you found this episode helpful, feel free to send it to a family member or a friend. We're trying to get the word out to as many people as we can. Thanks again for joining, and good luck out there.